can start. All right, Judge, may I open court? Yes, please. Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1014 et al. Trinity Services Group, Inc., petitioner versus National Labor Relations Board. Mr. Minor for the petitioner, Ms. Isbell for the respondent.
Minor, whenever you're ready.
Thank you, Your Honor. Good morning. My name is Fred Minor. I represent the petitioner cross-respondent Trinity Services Group, Incorporated in this case. This is a petition for review of a split decision by the National Labor Relations Board. The case involves an isolated discussion in which an employee brought to her manager's attention an alleged discrepancy in her accrued paid time off. The amount of PTO reported on the employee's pay statement did not appear to reflect the amount of paid time available to her. She testified in translation from Spanish that the manager said this was a problem her union caused. She needed to fix the problem with the union. The employee replied, there was no problem. She said, everything is okay. She understood the manager was not responsible for the PTO tracking system. A majority of the three board member panel nevertheless found a violation of Section 81 of the National Labor Relations Act, concluding the manager blamed the union for an error that was attributable to Trinity. Section 81 of the Act prohibits communications that are coercive, and Section 8C affirmatively protects communications that are not threatening. Under the board's precedents, absent coercion, even false and highly offensive statements are insufficient to find a violation of the Act. The statement here was neither.
Mr. Minor, how would you distinguish our recent precedent in the ingredient case? There, the court seemed to hold that a misleading comment could constitute a violation of the Act of 8A1. I mean, isn't that what the board found here, that there was a misleading comment and relied on ingredient?
The board found a misleading comment, Your Honor, absent any type of coercion and under very different circumstances. The ingredient case involved ongoing collective bargaining, in which a manager told employees or an employee that he should hold off applying for retirement because a better retirement package would be coming along in the future as a result of bargaining. And therefore, the employee should urge the union to come to the bargaining table and get serious about the bargaining process. That simply was not the case here. In ingredient, the union stood in the way, or the employer claimed the union stood in the way of a superior retirement benefits package by making a misstatement, a false statement about the status of the bargaining.
In ingredient, do you think there was a promise of a benefit?
There was an implicit promise of a benefit that constituted direct dealing with this employee. It was affirmatively and independently unlawful for the manager to pull this employee aside and assure him of a better retirement package in the future.
And we don't have any similar promise of a benefit on the facts here.
That's absolutely right, Judge Rao. There was no promise of any benefit. There was no threat of any retaliation. To the contrary, the employee received the PTO that she was entitled to. The misunderstanding that's being asserted here is simply a reporting error. The employee claimed that she had a different number of PTO days accrued on her pay stub. Unfortunately, that was incorrect. She did not have as many days available as she thought. She did receive her PTO. The manager did not suggest otherwise. I think it's also important to recognize that here the manager told the employee to go to the union representative. This is a problem the union can fix for you. The manager did not denigrate the union's status as her exclusive representative. To the contrary, he appeared to believe that this was something the union could assist her with. With respect to the misstatement involved, Your Honor, I also would add that just as the dissenting member, Chairman Ring, found here, the nature of the misstatement did not involve a claim of a loss of benefit or other adverse employment action. The issue that the union caused, according to the manager, was an issue relating to a reporting error that he believed was caused by confusion and complexity in the PTO benefit itself.
Do you think does Section 8C protect misstatements or misstatements of fact?
Thank you, Judge Rao. Yes, it does. It protects those statements, even if there are errors, even if they are offensive misstatements and denigrating of the union. We've cited several of those cases in our brief. The one thing 8C does not permit is coercion, and it specifically refers to threats of reprisal or force of promise of benefit. And that is specifically not what occurred here. With respect to this issue of confusion, as Chairman Ring found, the manager's report or the manager's statement was quickly followed by the employee's acknowledgement. I know you are not the ones that take care of the PTO system. The employee involved knew that local managers did not have control over the reporting system that resulted in the confusion that she found. She did not believe that the union was responsible for reporting PTO accruals. This was an issue she observed on her pay stub. No reasonable employee would attribute to her union representative an alleged misstatement on a payroll stub.
Was this exchange, this alleged exchange, did that take place during contract negotiations?
Thank you, Judge Randolph. It occurred after the final bargaining session at which the company presented its last best offer for a new contract to the union. And I think it's also important to...
And one of the, just to follow up, one of the contentions back and forth that I may be wrong about this, about in the contract negotiations was a revision of this whole system that was unique in determining paid time off. Is that right?
That's correct, Judge Randolph. So this particular employee was someone who was active in the union. She attended most of the bargaining sessions that were held between the committees for Trinity and the union. She knew that Trinity and the union had reached agreement on terms for a new PTO article that would provide the same PTO benefits other employees within the organization received. The purpose of that was to prevent the type of administrative complexity and confusion that was caused by this one.
Yeah, so what I'm wondering is whether this is even a misstatement, because if in fact it was made, the one meaning is, listen, one of the reasons that your pay stub is different than our calculations, because this thing is so complex, and we've told the union that we ought to straighten it out and get a simpler system. So that kind of a statement could mean, go tell the union to stop this. discrepancies. So.
Your Honor, we agree with that statement. The manager asserted a problem of confusion that he attributed to a unique benefit provided by this particular collective bargaining agreement. It was not false or improper to assert the union was responsible for creating a separate PTO benefit that was different from the PTO offered to every other Trinity employee nationwide. It was a confusing program. The PTO program under the expired collective bargaining agreement provided for a lump sum accrual at the beginning of the year, followed by monthly accruals during the course of the year, up to an established cap. It was a confusing document, and I think that's illustrated by the misstatement in the board's brief at pages 4 and 5 about how that accrual process worked.
Any further questions, Judge Randolph?
No.
Mr. Minor, we'll give you a few minutes for rebuttal.
Thank you, Your Honor.
May it please the Court, Kelly Isbell here on behalf of the National Labor Relations Board. First, I think we should talk about exactly what Unit Manager Rivera said to Ms. Victoria. He said, that is the problem the union created regarding PTO. You need to fix that with the union. When she said, I know you didn't do it, but the company should make sure we get our accrued leave, he said, that's the problem with the union. The cases, board and court cases, have long distinguished between misleading statements that tend to undermine confidence in or support of the union. We distinguish between those kind of statements and disparagement of the union or even vituperative speech. In situations where, I'm sorry.
Also, that statement that you want to focus on, does it include any threat or promise of a benefit?
The board did not find that it did. And under Ingredient, for example, I don't think the board needed to find that it had a threat or a promise of benefit. A misstatement is a separate category of violation under 8A1. It's a coercive misstatement. There does not have to be, Section 8C protects opinions and arguments that do not contain threats of reprisal, force, or promises of benefits. But this court was clear in Ingredient, based on language in the Supreme Court's decision in Gissel, that there does not have to be a threat. The issue is not whether or not there was a threat. The issue is whether or not there was a misleading statement.
Any case that holds a misleading statement is not protected by 8C that also did not include a threat or a promise of a benefit? Because I think in Ingredient, there was a promise of a benefit. So there's some language in that case that suggests that misleading statements alone might be sufficient, but arguably that's not consistent with the text of 8C, and it's not consistent with the facts of Ingredient, which also included a promise of a benefit.
Well, Ingredient, I'm not sure I agree that the statement made in Ingredient was also attached to a promise of a benefit. The statements were about you should bring the union to bargaining. Miller Waste, which was enforced in the Eighth Circuit, is also another case where there wasn't really any adverse action or, well, in that case they ended up giving they suggested they would not give a wage increase, and in the end they did. And then there's Westminster, that's what I'm thinking of, sorry, Westminster Community Hospital. That was just a case where the employer said, we can't give you better leave or better wages because we have an ironclad contract with the union and it's the union's fault. We can't give you better wages. And that case is very similar to—
So that's sort of a threat or the withholding of a benefit?
Well, in this sense, I mean, the board did not find that there was a threat in that case. And in this
What
case—
about the withholding of a benefit, right? The fact that we can't raise wages because of the union or because of our contract with the union does suggest, you know, something that better fits within the text of 8C. It's not just purely a misleading statement. I couldn't find any cases where there was a misleading statement that was found, to be a violation of the act where where the facts didn't have a threat or a promise of a benefit?
Well, I'm not sure that I agree about Westminster. They made the threat, or not made the threat, they made the comment, the misleading statement that the union kept them from giving better benefits, but there was no finding that there was an additional 8A1 violation, that there was a threat or withholding. They were talking about it in the terms of misleading employees about what the union did or could do for them. And it's very
how was this particular employee misled? I mean, she seemed to know how the thing was calculated, and actually the individual she was talking to, she let off the hook, and she was taking part in negotiations that involved this very system. What is the evidence that she was misled?
Well, Judge Randolph, under board and this court's law, when looking at whether or not a statement was misleading or coercive, the board looks at it from an objective basis. We don't look at it from whether or not a particular employee was actually coerced. It's whether or not a reasonable employee could have been misled by the statement.
So there's no evidence that she was misled. Is there any evidence that statement misled any other employees?
There is no evidence in the record that employees were actually misled, and there does not have to be evidence in the record that employees were actually misled. The question is whether or not a reasonable employee, whether the statement would tend to undermine the union, would tend to reduce. A
reasonable employee with knowing all the relevant and material facts. That's the test, isn't it? It's not just a reasonable employee. It's a reasonable employee informed of all the relevant facts and circumstances. And that kind of an employee knows that it's not the union that decides what the amount of the PTO is. It's the employer. So where's the mislead? How? I just don't understand how a reasonable employee would be misled by this awful.
Well, can I talk about this particular employee? Because there's been some suggestion that she had special knowledge. And
no. Answer my question. Is it what you say? It's an objective test.
Yes, Your Honor.
For misleading, and we have that kind of a rule in other areas, notably in the securities law area. Mm-hmm. But always it is coupled with this statement that it's a reasonable employee informed of all the relevant facts and circumstances. And what I'm asking is that if you find that employee, that mythical employee, with knowing all the facts and circumstances, I can't imagine how they could be misled into thinking that the union was calculating the PTO. That's impossible. Tell me how that's possible.
Our cases don't include that specific language, knowing all the facts and circumstances. Our cases talk about reasonable employees. And we can assume from an employee that would have a reasonable amount of knowledge of what was going on. But remember, these are food service workers. This is their only leave program. This is their combined vacation and sick leave. This was a very important issue to them, and they had been having trouble getting their correct leave balances for more than a year. There is no finding here that every employee understood exactly what was going on and why. They knew the grievances had been filed and that for an entire year they had not been able to get their correct leave from this company. Ms. Victoria herself had attended some of the bargaining sessions, but the judge made explicit findings that she was not on the bargaining committee, she was not a union steward, and she did not have any special knowledge about what was going on. This happened in the context of bargaining where a tentative agreement had been reached on the issue of PTO at the time of this discussion. But the contract was open. The union, according to the factual findings in the decision, the judge found that the union rejected the last best and final offer, so the contract was still open at the time, and the contract was not reached until April of 2018, so 4 months after this discussion. I don't think that any employee at that point knew exactly what was causing the problems. The factual findings show that it was not attributable to the union. It was patently false that the union created the problem or that the union had any responsibility for the problem.
But Mrs. Bell, even if it's a misleading statement, it might still be protected by 8C if there's no threat or promise of a benefit.
I disagree, Your Honor.
I mean, I think your arguments are all about whether, it's fits within the tests under 8A1, but that doesn't tell us whether it's protected speech for the employer under 8C. They're kind of two sides of the same coin.
I agree, Your Honor, but I think the board's cases distinguish between disparagement and vituperative speech, things like a children's center or trailmobile where a company says the union's wasting your money, the union steward's living it up at the Holiday Inn on your money, those kinds of statements, and statements that are misleading about what the union is doing for you and how hard the union is working for you. The board has long distinguished those kinds of cases.
Well, but what would be left of an employer's right to have free speech if statements that were thought to be incorrect or false were not protected? I mean, the ability to make, the ability to speak freely includes the ability to speak freely and be wrong, right? If there is no threat or a promise of a benefit connected to that mistaken statement.
It does to a degree, Your Honor. For example, if we're talking about an organizing situation under, say, Gissel, where an employer makes statements about how the plant down the street closed as soon as the union came in, or the union's going to go out on strike. Those can easily be statements that are not protected under 8C. Truth may get you out of it. Sometimes, depending on the context and the statement itself, an objectively true statement.
Is the union free to make misleading and false statements? Is that a violation of the National Labor Relations Act for a union official to do that?
I think it can be. I mean, I'm thinking of cases where a union has misrepresented board procedures or misrepresented board what the board has said about something. That could be. I mean, off the top of my head, I can't think of any particular cases like this. Usually it comes up in the context of initial organizing or negotiation bargaining, where the employer is discussing things with employees.
Mm.
I see I've run out of time. Are there any more questions?
Ms. Randolph? No.
No.
Thank you, Mrs. Bell. Mr. Miner? We'll give you an additional 2 minutes. I think you are muted, Mr. Miner.
Can't hear you.
My apologies. Is that better?
Yes.
Yeah.
Thank you.
I'd be glad to answer any additional questions that you or Judge Randolph has at this time. Thank you.
I don't have any.
Okay.
Thank you, Your Honor.
Okay.
Thank you. Case is submitted.
Case number 20-7051, Unsuck DC Metro Appellant versus Washington Metropolitan Area Transit Authority and Paul J. Whitefeld in his official capacity as General Manager of the Washington Metropolitan Area Transit Authority. Mr. Bekesha for the appellant, Mr. Shaw for the appellate.
Thank you. Mr. Bekesha, when you're ready.
Good morning. May it please the court, Michael Bekesha on behalf of Appellant Unsuck DC Metro. Washington Metropolitan Transit Authority asked this court to drastically rewrite the deliberative process privilege. Instead of a privilege protecting debate and candid discussion of agency decision makers, WMATA seeks a privilege to withhold information that may generate other information that then may be used as part of the decision-making process. This court has never held such information is protected, and it shouldn't do so today. There is no dispute that Unsuck DC Metro did not request the results of the survey questions or the analysis of the survey question. It only asked for the survey questions. questions that were asked of members of the public that were not sworn to secrecy or asked not to disclose. Questions that, according to the evidence submitted by WMATA, were not used by agency decision-making, or agency decision-makers to make any decision whatsoever. WMATA concedes this. In its
Mr. Cascia, before we get to the merits, I have a jurisdictional question. So Unsuck says that our jurisdiction here is based on Section 81 of the Compact. But that only provides for general jurisdiction against actions, against WMATA. It doesn't tell us what private rights of action a party may have against WMATA. The Compact doesn't appear to give any rights to obtain documents. And so the PARP is just a policy statement of WMATA. And it has a judicial review provision, but usually a regulation standing alone can't confer a private right of action, right, per Alexander v. Sandoval in the Supreme Court. So I guess, where does the private right of action come from here?
Yes, Your Honor. We think that's an extremely interesting question. At the district court, we brought several claims in the alternative because we are concerned for that very reason. Mm-hmm. And both WMATA and the district court found that the court had jurisdiction. It would have been weird for us to appeal. Not even sure we would have been able to appeal that question. And so at this point, we have just...
Well, may I interrupt you? I don't know that this is necessarily a jurisdictional question. It's like Doe v. Hood. Are you familiar with the Supreme Court's opinion in that case?
I am not, Your Honor.
Yeah, okay. Well, I won't get into the detail, but there's a difference between a cause of action and a court having jurisdiction. And I think what Judge Rao is asking is not a jurisdictional question as such, but it's really a cause of action question. And I am just as confused about that as Judge Rao is. Where does that come from? Where do you get the right to sue for the kind of relief you're seeking?
Sure. I mean, we believe it's found partly in the compact that was approved by Congress that says claims can be brought both in state or in federal court. And then the compact indicates that rules and regulations may be passed as necessary. And WMATA has done so when it comes to speaking of public records. And we think the compact provides that cause of action to the extent it does. Again, we had questions the same about whether or not there was a private right of action, whether or not there was a cause of action. We thought it may have even been a jurisdictional issue because is there, something like a federal question? It's not FOIA where there's a statute, and that's why we brought several claims in the alternative. The court found that there was a cause of action. Other district courts have found that there were causes of action. WMATA does not object. WMATA stood up and...
None of those things tell us where the cause of action comes from, Bill. I mean, the fact that the district court found one and WMATA has not raised this argument, there still needs to be we still need to locate the cause of action somewhere, and I'm not sure where that cause of action comes from here.
Yes, Your Honor. Unfortunately, as I said, we didn't brief this issue, and so if the court would like additional information, I'd be more than happy to provide it after the fact. But
while we're on the subject, before I want to give you some time to get your affirmative argument in. But in looking at this policy here, what's a couple things strike me. The policy in the appendix was not in effect when you made your request. So I don't know what policy was in effect when your request was made. Your request was made in 2018, as I recall. And this policy didn't go into effect until 2019. That's number one. Number two, I have no idea where WMATA gets the idea, as set forth in this policy, in policy number 9.3 or whatever it is, that it can decide what the federal courts can do and cannot do in terms of a cause of action. I mean, where's WMATA get the authority to do that? A federal agency couldn't do that. And then the other thing is that I think policy number 12 says that at least the one in the appendix doesn't apply retroactively. Can you answer any one of those questions? Let me tell you that these, I think, are more appropriately addressed to WMATA, but I just wanted to see whether you had any thoughts on it.
Thank you, Your Honor. I would have to take a closer look. Unfortunately, I don't have an answer about the timing of the policy. It may have just been an error on our part of pulling the wrong policy and putting it, but it's my understanding from WMATA that the PARP section, nothing has changed. That what we're talking about has the same provisions. So it may have just been updated. I just don't have an answer to that. Again, with respect to the other two questions, the Unsuck DC Metro had these concerns about what gave WMATA the authority to allow the federal courts to hear these types of cases. That is why we brought several claims in the alternative at the district court. We brought claims under the common law as well as the APA, because we believe it was highly likely that the federal courts didn't have the ability to hear a PARP claim. And
Mr. Bekesha, do you renew your APA claim on appeal, or have you? I mean, do you renew that claim on appeal, the APA claim?
We don't, Your Honor.
So that's not before us, the APA claim.
Correct, Your Honor. We only appealed. The court dismissed, on a motion to dismiss, the court dismissed our claims in the alternative and granted summary judgment on the PARP claim. We only appealed the summary judgment ruling, Your Honor. So you are correct there, which is why none of this is addressed in our briefs, Your Honor.
I think it's a difficult question whether WMATA would be subject to the APA, but that question, as you say, is not before us.
We think it's an open question that the courts haven't resolved, and unfortunately, it isn't before this court today. Same with some of our other claims regarding the First Amendment right.
Well, it really raises all kinds of questions. These policy statement, paragraph after paragraph, were they subjected to notice and comment rulemaking?
I don't know, Your Honor. I imagine WMATA would be able to answer those questions for you. What my client is concerned about and was concerned about when we brought the complaint was, to the extent PARP doesn't apply, WMATA receives millions, hundreds of millions of dollars from the federal government and from the states. And if PARP cannot be enforced, there is no accountability. There is no transparency when it comes to WMATA. And my client believes that's a big concern. It's part of why we brought these alternative claims. And I know those aren't before you now. And unfortunately, I don't have a lot of these answers because it is WMATA, not Unsuck DC Metro, that has really been advocating that these PARP claims are proper in the federal court. I see my time is up. I'm happy to talk about the merits of the summary judgment brief, but based on these questions, I'm not sure if the court wants to hear them or not. So I guess I'll reserve time to respond afterwards.
Judge Randolph, any further questions?
No, not at the moment.
Thank you. Mr. Shaw?
Thank you, Your Honors. May it please the court, Pratik Shah for the appellees. I'm happy to address some of the threshold questions if this court would like. as my friend on the other side stated, WMATA did not object on the ground that there was no cause of action. I don't think there's any question that the federal court has jurisdiction pursuant to Section 81 of the compact. I think it does afford this court, the district court and this court jurisdiction to hear any claims that are brought against WMATA. I do think there is a question that you raise about the cause of action. WMATA has always viewed the cause of action as arising from Section 9.31 of the park policy, and that's at JA page 90. And that section says it's under the judicial review provision. That section says the requester may bring a civil action only for injunctive relief or declaratory judgment. Nothing in this policy shall be construed to authorize any civil action for damages.
Mr. Shaw, I mean, under Alexander v. Sandoval, a regulation can't create a cause of action where there isn't one in the underlying statute. So I don't see any cause of action created by the compact if we're going to analogize the compact to a statute. So is your view that WMATA has more ability to create a cause of action than a federal agency with delegated rulemaking authority?
Well, Your Honor, this is what WMATA's policy has said. Its intent has always been to afford a forum to members of the public if they disagreed with the decision in that. Now, if this court obviously finds as a matter of law that WMATA can't do that, or that it would exceed a federal court's authority to recognize a cause of action, then the court obviously has authority to find that, and a plaintiff could not, in fact, seek relief in the federal court under that provision.
Would you tell us how these policies come into being?
I don't have. I know that they were first enacted in 2000, I believe. So, Your Honor,
when you say enacted, what do you mean by enacted?
They were promulgated by WMATA. WMATA is obviously, its position is it's not subject to the APA. I don't know when it was enacted, whether there was some form of notice and comment outside of the APA that WMATA subjected this to. I just don't have the...
Do Virginia, D.C., and Maryland all have to approve this?
They do.
It says in the copy we have that the approval was done by a manager.
Yes, Your Honor. So it was finally approved there, but this, as you noted, was the kind of 2019 version of it. The part dates back prior to that. So what I don't know is in 2000, when it was originally promulgated, what sort of process it was put through. And
it could be, well, the in the lower left-hand corner of the page, it's page 90. Mm-hmm. It's every page, but it's approved by somebody whose name I can't read because the lights aren't so good here. But it doesn't say it was approved by D.C., Maryland, or Virginia. It's just the manager.
Yes, Your Honor. And I just don't know when the original part policy was promulgated, what the exact process was at that point. So I can't speak to that.
But what about the policy that was in effect when this request came in 2018? We don't have that in front of us either.
Your Honor, it's not included in the JA. The other side put together the JA. I think they probably just pulled the one from the website that had this date. None of the provisions that are material in this case, my understanding, were any different in 2018 than they were in 2019 when the suit was brought.
Why then promulgate new ones?
There may have been other changes, Your Honor, that aren't at issue in this case. But in terms of the exemption, the 6.15 exemption, that's always been part of the park policy.
Mr. Shaw, so if we just assuming for a moment that there is a cause of action, I guess I'm wondering why a survey question standing alone would be covered by a deliberative privilege. And so I was thinking of an analogy. I mean, in the context of other agencies, other federal agencies, when they do information collections from the public, right, their surveys or their forms have to go through the Paperwork Reduction Act, which involves subjecting those forms to, a form of notice and comment. So if the PARP is sort of incorporating FOIA, I understand it's not incorporating the Paperwork Reduction Act, but I think it would be very unusual for survey questions from other federal agencies to be covered by a deliberative privilege because of this other statutory regime that requires them to be made public and to ensure the public is notified and given a chance to comment. So I'm not suggesting WMATA is covered by the Paperwork Reduction Act, but I do think it suggests that something like questions standing alone wouldn't be part of something protected by a deliberative process.
Judge Rao, if in fact questions were subject to some public notice and comment and they were published out there, it wouldn't be protected by FOIA, but that would be for a different reason than what we have here. That's because the questions would be part of the public domain. And this court has a bunch of case law on disclosures in the public domain. The other side has not made that argument, and that's because these questions are not, in fact, in the public domain. And there are cases that set forth the test for the public domain. Is it captured in a permanent public record? Obviously, here we know on the facts here on the declaration, it's undisputed that these questions were not disseminated broadly. They were targeted to a select number of WMATA customers, and WMATA took special precautions to make sure they were not, in fact, publicly disclosed beyond that. They provided these surveys only through a telephone, only through two means: a telephone survey, so you couldn't, copy and paste it from a website and disseminate it, or through a closed email link. And that closed email link was targeted to a particular individual. If you forwarded it to someone, it wouldn't work. And even if you clicked on it, the questions would come one by one. So this was all done in a way that was tailored to minimize any public disclosure. I agree with you, Judge Rao, if you had a case where the questions were published in public under that public domain doctrine, you wouldn't have that. But here, there's no doubt that the survey questions are not, in fact, public within the meaning of that test.
I guess my question is not just about the fact that they would be made public. It's just that things that are surveyed to the public are not ordinarily thought of as part of what we consider part of a deliberative process, like within an agency or between agencies.
Well, Your Honor, I guess I wouldn't think of this as kind of a broad public survey. This is a targeted customer satisfaction survey that's part and parcel, and this is undisputed through WMATA's declaration. This is a core part of how they make policy in WMATA to improve the transit operations. And so this is not some broadly disseminated survey. If you wanted to have an analogy, Judge Rao, I would analogize this more to a targeted focus group that you might bring in to aid your policy-making process. That's the way in which WMATA uses these questions. It's part of their policy-making process that they go through to decide, are there particular areas that they can improve as a transit agency? There's no doubt that it satisfies the test that this court has set forth. It's certainly pre-decisional. The whole point is to have these questions and answers aid the decision-making process. And two, it is certainly part of the deliberative process. In fact, it delineates the topics on which input is solicited, upon which then WMATA can make its decisions with respect to transit operations. So I think both prongs are amply satisfied here, as the district court found below.
Mr. Shah, if we were further interested in this question about the cause of action, do you think we would need additional briefing on that question?
Yes, Your Honor. It wasn't briefed either in the district court or in front of the Court of Appeals. WMATA has always proceeded pursuant to its policy. And so, yes, I do think if you are interested in that cause of action question, it would benefit from briefing. If there are no further questions, I see that I'm coming to the end of my time.
Judge Randolph?
No.
Okay. Mr. Bekesha, we'll give you 2 more minutes.
Thank you, Your Honor. The deliberative process privilege, the purpose of it, that this court and almost every other court has found, is to prevent the chilling of candid advice. We just don't believe that questions asked of the public would chill candid advice in the future. Just hypothetically, if one of the questions is, do you ride the Metro? If that question is then, if that piece of paper, if there's a piece of paper given to the WMATA general manager that says, do you ride the Metro? How does that help his decision in any way? What if the question is, on a scale of 1 to 10, how clean is the Metro? How does that provide any information whatsoever to decision makers? And so what we have here aren't, the culling of factual information. We don't have picking and choosing what information is being used and what information isn't being used. What we have here are just survey questions. And I've litigated a lot of deliberative process cases over the past 11 years, and I've lost quite a few of them. And, this one just doesn't seem to fit into the criteria that the courts use when looking at information that is deliberative and needs to be protected. These are just very different. WMATA lists a bunch of reasons why the information needs to be disclosed, a lot of potential harms it may have. However, none of those harms are the chilling of candid advice or discussions. There are, other reasons that don't fall within the deliberative process. And for that reason, we do not believe the deliberative process applies.
Thank you. Case is submitted.
Case number 20-5100, Food and Water Watch, a nonprofit corporation, appellant, versus United States Department of Agriculture, an agency of the United States government et al. Ms. Heinzen for the appellant, Mr. Bushbacker for the appellate.
Heinzen, good morning.
Good morning. May it please the court, Tara Heinzen for appellant Food and Water Watch. The U.S. Department of Agriculture's Farm Service Agency guarantees farm loans of last resort, loans to farms that could not obtain financing without the government's backing. In this case, the agency has guaranteed a more than $1.2 million loan for a large contract chicken operation that raises more than 1 million birds each year for vertically integrated meat company Allen Harim in Caroline County, Maryland. This location was selected specifically because it's already home to numerous other Allen Harim chicken operations, though it's adjacent to high-quality Watts Creek, and both the local Choptank River and the downstream Chesapeake Bay are significantly polluted by agricultural runoff. The loan guarantees NEPA environmental assessment, short-changed analysis of the facility's environmental impacts in several ways. But first, I'd like to briefly address standing. Chief Judge Howell got it right when she found that Food and Water Watch's injury here is redressable because there's no real doubt what the third-party lender and borrower would do in response to the court granting the relief requested, which is to vacate the environmental assessment and the loan guarantee. In this circuit, a plaintiff need not show to a certainty that a favorable decision will redress this injury. A significant increase in likelihood of relief is enough. Appellant meets this standard because this is not a case where truly independent third parties are making unfettered choices, as in Lujan, leaving the court to speculate that they would agree to conditions included in the new loan guarantee following additional NEPA analysis ordered by the court.
Ms. Heinzen, how do we know that a loan guarantee would even be sought again? So now this loan's been in place now for several years. The farm is an ongoing concern. How do we even know that, is there any evidence in the record that the lender would seek an addition, like another loan guarantee in the current circumstances?
Absolutely, Your Honor. First, standing is, of course, judged at the time of the complaint, not under current circumstances. And here, the agency, the lender, and the borrower are all bound up together through the loan guarantee and the loan itself. If the guarantee is vacated, the lender has a strong financial interest in restoring the protection of a federal guarantee for the remaining majority of the loan's duration. At the time of the complaint, they were just 2 years into a 15-year loan guarantee with more than $1 million still owed. So from the lender's perspective, the interest in a guarantee for $1 million loan is essentially the same as for a $1.2 million loan. and there is a strong indication that their same incentives will apply.
But you say a strong indication, but is there any evidence that the calculation for the bank is the same 2 years into the loan as at the outset when there's no farm and no ongoing business?
Well, Your Honor, the lender's perspective is not represented in the record directly, but the borrower's incentives at the time of the complaint were even stronger than at the time of the loan. Again, we're just 2 years into a loan of last resort, and this borrower had put a lot on the line for this financing, including others' property as collateral. So she has the incentive to maintain her home, her collateral, and her business. And there's no serious doubt as a result that both the operator and the lender would comply with conditions on the new guarantee to protect these financial relationships. The lender's interest here is very much like in Bennett v. Donovan, where the court looked to the lender's financial interest in allowing the agency, which in that case was HUD, to take over a reverse mortgage. In that case, the court found it was reasonable to see that there was a path to redressability because the agency could choose to offer to the bank to take over the loan, and that the lender would likely agree to do that. Here, the lender's financial incentives are even stronger.
Was this case decided on summary judgment?
This case before us today, yes, Your Honor.
Yeah. You know, you say standing has to be assessed at the time of the complaint. That's true, but this is the point. The question, the evidence that can be considered at the complaint stage is your allegations. But when you get to the summary judgment, Lujan holds that you have to prove the allegations to establish your standing. And so that doesn't answer the question that Judge Rao raised, which is where is the evidence at summary judgment that any of these scenarios that you're putting forth would possibly or probably come true?
Well, Your Honor, we did not seek discovery in this case after early in the case. Chief Judge Howell found that we had demonstrated redressability based on the information in the record. On the basis of the allegations in the complaint, but what about its summary judgment? Well, Your Honor, in this case, we didn't think that discovery was necessary because the information in the record at the time of the complaint demonstrates the financial incentives are very strong, and the standard for redressability here is that it is likely that the third parties would take this action. We don't have to demonstrate that to a certainty. And the court has repeatedly looked to third parties' past actions and their financial incentives in looking to whether they would be likely to act in response to a government action. And in this case, under the circuit case law, that should be enough. Here there are clear financial incentives in play. The agency has essentially tried to make this about the situation today. It has speculated that the borrower's finances may have changed dramatically during the pendency of the litigation, but the agency is here trying to reprise its failed mootness argument, and it has not provided any evidence to meet its burden that the case is moot, and that the court cannot grant any effectual relief whatever.
Ms. Heinzen, I will ask the department this as well, but I guess I have a concern that this case might be moot under the recently enacted NEPA regulations, right? I mean, those provide that loan guarantees and specifically mention FSA loan guarantees as not being major actions within NEPA. So even if we were to grant the relief that you seek, vacate the loan guarantee and the environmental assessment, why would USDA have to even do another environmental assessment, even assuming that the lender sought a loan guarantee?
Yes, Your Honor. Well, as the agency points out in footnote 1 of their brief on pages 6 and 7, the Farm Service Agency has stated that it intends to proceed under its status quo of its own agency NEPA regulations.
So I'm aware of that, but the NEPA regulation itself says, let me see, hold on. It says that the regulations in the subchapter apply to any NEPA process begun after September 14th, 2020.
Yes, Your
right?
Honor.
So a NEPA process, so if they were to issue a new loan guarantee and start a new NEPA process, that would not be an ongoing activity, I think, under the meaning of the new revised NEPA regulations. Or I guess, what's your account of why it would be?
Well, Your Honor, the agency's own specific NEPA regulations are still in effect, and they still do require an environmental assessment for a facility of this size. And so as long as those regulations are still in effect, and of course, the Council on Environmental Quality regulations are currently in litigation, the agency...
Actually, you have a better answer, and the answer is that the CEQ, which is a part of the Executive Office of the President, has no rulemaking authority. And so those rules, or whatever they are, they're interesting, but they're not binding on any particular agency. And we recognized that problem with CEQ a long time ago in a footnote in an opinion dealing with the building of the bridge south of Washington, where an environmental impact statement was required. So I don't know that you can. I don't know that you can even have to distinguish the new NEPA CEQ regulation.
Thank you, Your Honor. If there are no additional questions on standing, I'd like to turn to the merits. The agency here failed to take a hard look at the facility's cumulative impacts. Here, the circuit case law requires environmental assessments such as this one to have a cumulative impacts analysis that considers past, present, and reasonably foreseeable future actions to determine the overall impact that can be expected if individual impacts are allowed to accumulate. By definition, cumulative impacts can result from individually minor actions. Here, the Farm Service Agency did not conduct any meaningful cumulative impacts review, overlooking the existing concentration and expected future expansion of the area's chicken industry, and providing no actual analysis of the facility's incremental impact against this background. Regarding past and present actions, the assessment makes clear that this entire project is premised on fostering chicken industry consolidation, and the agency is trying to have it both ways by expressly relying on Alan Harim's existing concentration to define this project's purpose and need, and to reject alternatives such as other locations, while ignoring the cumulative impacts of doing so. The assessment does acknowledge that the Upper Choptank River and the Chesapeake Bay are impaired by pollution and subject to a Clean Water Act cleanup plan known as the total maximum daily load. But this is not enough to salvage the conclusory cumulative impacts analysis here for two main reasons. First, assuming that this cleanup plan will account for cumulative impacts overlooks impacts to high-quality Watts Creek. The total maximum daily load is meant to attain certain water quality standards in the Choptank River and the Chesapeake Bay, but it is not intended to ensure that Watts Creek maintains its high water quality. Watts Creek is immediately adjacent to the facility and is a waterway one of Food and Water Watch's declarants relies on for fishing every year. Second, even if the Bay Cleanup Plan were an acceptable baseline to look at this project's impacts, establishing the baseline is only the first step. This court recently confirmed that the cumulative impacts review requires substantive analysis of how the present impacts of past actions would combine and interact with the added impacts of the decision. But here, the only place that the assessment discusses the project's pollution in the context of baseline conditions is in stating that surface water quality measures will be implemented in accordance with various permits and the requirements of the total maximum daily load. This simply provides no analysis of impacts at all, and this court has repeatedly rejected such simple, conclusory statements of no impact. This lack of analysis is largely due to the agency's impermissibly substituting other agency standards and permits for any independent analysis of the farm's cumulative impacts. The agency here simply assumes that Maryland agency's permits and the total maximum daily load will ensure no significant impact. So this court has established that assuming other agencies' permits will ensure no cumulative impact with no independent hard look is arbitrary and capricious, because relying wholly on other agency standards would render NEPA's procedures superfluous. The court further recently held that the existence of permit requirements overseen by another federal agency or state permitting authority cannot substitute for a proper NEPA analysis.
Let me just ask the courtroom deputy, have we lost Judge Randolph just by video, or also is he here with us
Judge Randolph is with us. He just turned his video off.
Okay, that's fine. I just didn't want him to miss.
Thank you, Your Honor. This independent analysis by the Farm Service Agency is critical here because the record shows that such chicken consignments do contribute pollution and that the permits at issue here are not meant to result in zero pollution. In other words, total maximum daily load or not, this agency decision allows a new source of pollution into several waterways. The agency further erred in failing to consider foreseeable future actions. The agency itself here plays a role in determining where these chicken operations will locate through its loan guarantees, but it claims that all future impacts are simply too inchoate to evaluate. The record contradicts this claim. The Farm Service Agency loan officer for this project stated in an email to concerned citizens that there is a land war going on with people buying property to build chicken houses. This court held in Delaware Riverkeeper Network v. FERC that an agency need not foresee the unforeseeable, but reasonable forecasting and speculation is implicit in NEPA, and the court should require that here. Similarly, the agency's reliance on draft and generic mitigation plans was arbitrary and capricious. For an agency to rely on mitigation measures, its reliance must be reasonable, and that means that there must be some evidence and some analysis establishing that the measures will be effective in preventing significant impacts. Here, the agency's own regulations further require that mitigation be practical, enforceable, and tailored to fit the specific needs of the action. Nonetheless, the agency here relied on draft mitigation measures that were not well enough developed to determine they would be effective, and again, failed to ensure that they would be tailored to the project or independently analyze their effectiveness. The most stark example is the nutrient management plan. The assessment says surface water impacts will be managed by best management practices that will be outlined in the nutrient management plan and conservation plan. This nutrient management plan, in turn, can include such open-ended practices as identifying site-specific conservation practices. So in effect, this is nothing more than a plan to make a plan. The court recently rejected just such incomplete mitigation in American Rivers v. FERC and should do so again here.
Ms. Hyndon, I see you are out of time. Judge Randolph, do you have any further questions?
No.
Okay. Thank you.
Thank you.
Now hear from the government.
Thank you, Your Honor. May it please the court, my name is Michael Bushbacher from the Justice Department, representing defendant appellees. I'd like to begin with standing before turning to the merits. Plaintiff hasn't shown how a victory here could lead to redress of any of its alleged injuries. Now, I want to focus on one important point that plaintiff didn't talk about, which is the farmer. We agree that before she obtained the loan, the farmer had an incentive to support the lender's application for a loan guarantee. Without that guarantee, she probably would not have gotten the loan and then might not have been able to start the farm. But that incentive evaporated once she received the loan more than 5 years ago. Under Lujan, the burden is now on plaintiff to present affirmative evidence showing why the farmer and the lender, after having executed that loan agreement, would nevertheless be likely to agree to new and, for the farmer, potentially costly mitigation measures. Vacatur of the guarantee itself doesn't get plaintiff what it wants. Vacatur would change the risk allocation between the government and the lender, but it wouldn't affect the validity of the loan unless one of two things were the case. The first is that there's some kind of contract provision that the farmer agreed to that would put something like that in effect. And the other is if the agency itself had the legal authority to impose new conditions on the loan. Plaintiff hasn't made any contract arguments here. So option one's not at issue. And as for option two, plaintiff is just incorrect in its brief where it talks about the regulations that Farm Service Agency had in place at the time, 7 CFR section 1940.318G and M. Neither of those subsections authorizes the agency to impose new requirements on a loan agreement. Subsection G, that applies only to ongoing applications. As Judge Rao pointed out, why would the parties here, or not the parties, the non-parties, the farmer and the lender, agree to start that process again? Especially for the farmer, she has no incentive to do so since there's only a downside that's in the offing for her because it's there's a likelihood that she would have to comply with new and potentially costly mitigation measures, but she wouldn't get anything in return. She already has the loan. So there's no evidence that they've pointed to that would show that there is some reason why the parties would, to that agreement, would again seek a new loan guarantee. And as for subsection M, I think that's where plaintiff put the most emphasis in its brief, but that also doesn't allow for changing executed contracts, certainly not contracts like the loan agreement, which are between the lender and the farmer, in which the agency is not a party to. That provision just says that the approving official should consider comments and other information that's received after an approval has been issued.
Did the Farm Service Agency or Agriculture adopt the new amendment by CEQ to their regulation?
So the new CEQ regulations do purport to be binding on all federal agencies, including Farm Service Agency. It's currently actually a case before the District Court of DC about the scope of how that interacts with the agency's own regulations. The United States' position there is that the Farm Service Agency's current regulations continue to govern. To Judge Rao's point earlier about
what is the basis for the?
You recognize that CEQ traces its authority, even in the most recent iteration of the regulations, to no federal statute. It's an executive order that President Carter issued setting them up.
Yes, I do recognize that. Like I said, there is a dispute about whether the new NEPA regulations require FSA immediately to implement those restrictions about loan guarantees, or whether the agency is bound to, that the agency can bind itself by issuing new regs, and at that point the change happens. I don't know if that makes sense, but the dispute is about, that case is about ripeness and whether the CEQ regulations are sufficient to make a right dispute.
Okay.
More.
The government, I'm sorry, is this the government's position that the CEQ regulations are binding on other agencies or not binding?
They are binding.
That is the government's position.
That is the government's position.
Mm-hmm.
The question here is
it wasn't that's a new position, a relatively new position. I can tell you from personal experience, back in the ancient past, that the government's position was that they were not binding. So
ultimately, I think that point is not relevant here. This is not a procedural injury standing argument, in the sense that there are third parties whose independent conduct is really where the focus is. We've, for the purpose of standing, when it comes to getting what they want from the agency, we're not contesting that they could get a different result. That's been our position in this lawsuit. And certainly that was the case at the time.
Is relevant for us, I mean, in terms of mootness, though, because if the CEQ regulations are binding, then I think there's a live question of mootness. I mean, they may not be binding for the reasons that Judge Randolph gives, but if they were binding, then would this case be moot?
I think so, Your Honor. I think that it would be mooted if it's binding and the agency doesn't have discretion to wait to implement it pending its further regulations. So I think that second point is crucial.
And what's your argument on the second point?
Yeah. On the second point of what? I'm sorry.
About whether the agency must follow the new regulations now, before promulgating its own regulations.
We certainly believe that the agency has an obligation to follow NEPA and the new regulations. Our position is that I'm sorry, it's been a while since I've looked at the briefing in that other case. Our position is that that those Farm Service Agency regs that they are working on and will promulgate, that it's not in conflict with the new NEPA for them to do that.
Yeah. I have to interject it. I recognize in talking about the validity of the CEQ regulation or the binding effect that there's some language in a Supreme Court case or our cases saying that they're binding or they're mandatory or whatever. But I kind of view that in the same way as if the court takes jurisdiction without considering the underlying problems with asserting jurisdiction. So I don't know that those cases are necessarily conclusive in res judicata or whatever collateral estoppel cases.
Your Honor, I would just say that because you can consider questions of mootness and standing in any order that you want, we would ask you to look at our standing argument first before considering any mootness argument sua sponte. And on the standing point, they just don't have the evidence. It is, as Judge Randolph pointed out, their burden to come forward with something showing why they could get redress, and they haven't done that. And we certainly agree that the relevant point in time for that is when they filed suit. And our brief says exactly that, and they've only selectively quoted it in their brief to suggest otherwise. We've said all along that from the time they filed suit through today, they don't have what it takes to demonstrate standing. Before turning to the merits, I just want to respond quickly to that idea that the parties, the FSA and the farmer and the lender are all bound together. Well, they're bound together in one sense, but not in the sense that they all went through the loan guarantee process the first time, and that there's an executed loan guarantee and there's an executed loan agreement, but they're not bound in some sort of future sense. They're not required to go forward and engage again in some renewed process here. That process is entirely voluntary. This is not, as the district court, I think, thought, a case where there's some sort of regulation in place. This is simply a voluntary thing. Anything that happens in those discussions that leads to an agreement, what's binding on the parties is a result of a contract, not a regulation. So turning to the merits, I think there's a lot that's going on in the brief, but there's really, I think, only one thing that you need to know. And
I just want to go back to a little bit about the redressability question.
Yes, Your Honor.
Suppose the district court issued an order staying the effect, holding that the loan guarantee was void, but staying the effect of that until the parties or until an environmental assessment was redone. Would the case be? Would there be a standing problem then?
The standing problem here doesn't stem from anything that would happen before the agency. The standing problem here, in terms of reconsidering the EA, the standing problem here is that there is nothing to suggest, certainly nothing plaintiff has pointed to, that the farmer would have any incentive to agree to bind itself to potentially costly new mitigation measures when it gets nothing in return.
But that assumes that there's going to be more costly mitigation methods.
Well, Your Honor, I'm assuming that because on a procedural injury case, the way to look at what the agency does is to just assume that the plaintiff gets kind of the best case result.
The best case result in an environmental impact or even assessment case is informational, that the agency, namely the Farm Service Agency, will get more information before it again makes its decision.
I think plaintiffs not looking for information. They haven't alleged an informational injury here. Their point is that we either shut down the farm by bringing the suit, or we at least get some kind of mitigation measures. That's the redress that they're seeking. They're not seeking additional information.
But even if the assessment turned out to show that there's going to be massive pollution in the Chesapeake Bay as a result of this farm, the Farm Service Agency can still go forward.
It certainly can still go forward, Your Honor. The regulations that were in place at the time did encourage the agency to consider mitigation measures, and so that's why instead of putting our argument into fighting how exactly the agency might be able to resolve things and what the scope of that would be, it's the clearer point here is that there's just nothing that that's in the record that shows that the farmer would have any incentive to do anything, and that's really all you need to know. All those other points are true and considering, I think, but the easiest point here is just that last one, in my opinion, at least.
Okay.
I've only got a couple of minutes left, so I want to quickly hit on the merits, if that's all right with you.
Sure.
I think the crucial point here is plaintiff has not renewed their hard look objection, and so if the agency reasonably determined that the design features of the farm made it likely that it would have only minimal and localized negative effects, you can find that determination on Joint Appendix page 669 through 70. If that's correct, and plaintiff hasn't appealed the district court's decision on that point, if that's the case, then the cumulative impacts analysis is quite simple, simply because cumulative impacts looks at incremental impact. If there's no incremental impact from the farm and in any of the areas that they're concerned about, that puts an end to the inquiry. And now I grant, of course, that the agency didn't say that there would be zero impact and some kind of metaphysical certainty, but I point the court to Minisync, which said that when the project itself is expected to have minimal impacts, no significant cumulative impacts from related actions need to be considered. And I think the agency did look at a lot of other things, including the TMDL on Caroline County more generally and the Upper Chalk Tank. But the point here that's most crucial is that if you have only minimal impacts, there's nothing to add to those that makes it significant. And that
and Kleppe versus Sierra Club held that the determination of the geographic scope and cumulative impact is up to the agency to decide.
That's correct, Your Honor. And I would say that there's two parts to the geographic analysis. One is looking at the scope and looking for what kind of effects might be out there. And the second is actually determining where the effects are going to fall. So when plaintiff tries to conflate these 2 points, I think, but when you think about it, the consideration of all the stuff more broadly was just a part of the agency's determination that, in fact, this farm has only minimal and localized impact, and that's dispositive. I see my time has run out. If there are any other questions, I'd be happy to answer them. Otherwise, I guess I'm already sitting down, but I'll sit down.
Mr. Randolph? No. Thank you, Mr. Bushbacher.
Thank you, Your Honor.
Isaac, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. On the cumulative impacts point, finding that a facility will not have significant impacts on its own does not mean that it cannot have cumulatively significant impacts, and the district court got this point wrong. In the Minisync case, this circuit found that a facility would not have individually significant impacts, and it also found that it would not have cumulatively significant impacts. But that case was in large part determined because the impacts of concern had to do with construction, and the timing of the different projects were different. So the impacts did not aggregate. The district court erred as a matter of law in finding that a facility without significant impacts on its own could not have cumulatively significant impacts. And permits that purport to minimize impacts don't change that analysis. This is the entire point of the cumulative impact review. On the question of whether staying in order to vacate the guarantee would cause a standing problem, I believe it would not, because standing is evaluated assuming that the plaintiff will get the relief requested. The court did the same thing in Friends of the Earth v. EPA, where it vacated a total maximum daily load and then stayed that so that there would be protections in place for the waterway.
Would you define for me what you are claiming is the harm to the members of your organization?
The injuries here...
From the failure to properly prepare an environmental assessment.
Yes, Your Honor. So this is a procedural injury from the agency, but the injury, in fact, experienced by our members. Mary Lou Miller lives next door to this facility, and in her declaration, she has suffered injuries related to odor and flies and noise and bright lights. She's impacted on a day-to-day basis. Her quality of life has suffered. Our other member declared...
But I thought in environmental impact statements and environmental assessments that the ultimate decision of the agency is not up to an environmental impact statement, and it's not up to an environmental assessment. All they're designed to do is provide information to the agency on which to make its decision. So the injury that you're defining, it doesn't seem to me to be connected to the purpose of an environmental impact statement. The purpose is to give information to the agency, and you as or members, your members, injury, it seems to me, would be that the agency went ahead and made a decision without having sufficient information.
Well, Your Honor, we meet the relaxed redressability standard under NEPA for the agency's action here, but we have to satisfy the normal redressability standard to show that if the agency were to impose additional guarantee conditions following NEPA analysis, we don't have to show that they would. But if they do, we do have to show that it's likely that the third parties here would agree to those conditions, and we believe we've done so in this case. And I see that I'm out of time.
Okay.
Thank you.
Thank you. Case is submitted.
Honorable Court is now adjourned until Monday, January 11th at 9:30 a.m.
Goodbye.